Estate planning is the process of making preparations and leaving behind legally recognized instructions on how you want your assets and possessions to be handled once you pass on. Not doing estate planning can be costly for your other family members, including not being aware of your existing bank accounts, life insurance policies, and not knowing how to manage a sophisticated investment portfolio or appointing the right person to inherit your business. Also, if there is no will or estate planning done, your assets will be distributed according to the intestacy laws, which may not be in line with what you want. What are the consequences of not doing proper estate planning? Your family can lose money through these ways. Firstly, forced liquidation of assets. Assets like houses and properties needs to be sold before proceeds can be split up among the beneficiaries. They could be sold at unfavorable prices due to bad timing or a rushed time frame. Secondly, heirs can't manage your portfolio. Without a structured plan from you, your heirs may not know what to do with your investment portfolio or what you wish to achieve from it. Thirdly, family not knowing about assets. If you don't pull up a full inventory of assets you hold, your family members might not be aware of all existing assets that you have. Fourth, family has to pay your debts. If your family members are co-signers on your loans and credit cards, they will be responsible for the debts you leave behind. What happens legally when you pass away? Before any assets could be distributed to the beneficiaries, your assets have to first be used to settle any debts that you are liable for. Everything of monetary value that you leave behind makes up of your estate. This includes bank accounts, properties, investments, and insurance policies. The exception to these are your CPF funds and assets held in trust which can't be used to pay your creditors. If you do not make a valid will and have an estate not exceeding $50,000, your family members may apply to public trustee for them to administer your assets in accordance with the Interstate Succession Act. Once you pass away, all of your assets will be frozen. The appointed executor of the will then apply to be granted probate to settle your liabilities and distribute any assets that are remaining after paying off your existing liabilities. What happens to your bank account, house, property, and other physical assets? Closing bank accounts. Once the banks are notified that you have passed on, all of your accounts will be frozen till they are closed. There are 3 steps which your family members can follow to successfully close your bank account. Firstly, look for the will. You would have stated in your will how you want your assets, including your bank accounts, to be distributed. However, if you do not have a will, they can proceed to the second step. Secondly, apply for legal documents. To close the bank account, your family members have to apply for legal documents from the court. It could take up to 6 months depending on the legal advisor and the complexity of the case. Thirdly, notify and close the bank account. Visit any bank branch to inform and close the account. All the legal representatives must be present at the bank branch for the closure of the account and release of funds. Other than your bank account, what will happen to your HDB flat or private property if you were to pass on suddenly and without a will? When you do not leave a will, the intestacy laws of Singapore will come into the picture. Intestacy laws is the law that governs when people pass away without a will, and it applies to both HDB and private properties. However, if you have not fully paid off your property and there is still an outstanding loan on it, the bank has the first charge over the property. This means that to inherit the property, your beneficiaries also inherit the loan, but they will also be subjected to the total debt servicing ratio framework, where their monthly loan prepayments cannot exceed 60% of their gross monthly income. In the case that the beneficiary does not have the ability to carry the loan or does not wish to, the bank will then auction off the property. For example, if a 70-year-old mother who is retired and does not have any savings or monthly income, who is the beneficiary to her deceased child's HDB flat, she does not have the capability to service the remaining housing loan. Hence, she will not be able to take over the HDB flat and the property will be auctioned off by the bank. There are also a few exceptions to your assets that do not form and fall under the estate upon your death. Firstly, CPF nomination. As mentioned earlier, your CPF funds and your monies do not fall under your estate. Thus, you will not have to make a CPF nomination to specify how you want your CPF funds to be distributed after your passing. It includes your CPF savings in your ordinary, special, MediSave, and retirement accounts. Secondly, insurance proceeds. trust nomination. A trust allows you to create a trust over your insurance proceeds for your beneficiaries. This means that upon your death, the proceeds from your policies will be received by a trustee who will then pay the nominees or beneficiaries, which then also means that you have given away all the rights and the benefits of your policy to your beneficiaries. Therefore, you cannot override the trust nomination using a will. Once the trust nomination is made, you will need to obtain written consent from your trustee or beneficiaries to make any changes to the policy. One major benefit of trust nomination is the protection of the policy proceeds against claims from your creditors. The insurance proceeds do not form part of your estate upon your death, hence proceeds will not be distributed by your executor according to your will. A trust nomination, however, may be revoked with the trustee or nominee prior written consent. Revocable nomination. A revocable nomination allows you to allocate the death benefits of your policy to your loved ones and the people of your choice. It does not just have to be your spouse or your children, it could be anyone. In a revocable nomination, you don't have to name a trustee as well. You will still retain your rights as a policy owner and can make changes to your policy without obtaining consent from your beneficiaries. As you still have your rights to your policy, the living benefits will still be given to you, while only the death benefits will pay out to your beneficiaries. If you have not done your estate planning, you should take stock of your current assets and liabilities and make a will that includes a plan to ensure that your financial matters are handled in accord to your wishes. Please subscribe, like and share our video. Thank you!